Now, she has just, as you'll hear during the course of the day, demonstrated a defense, an affirmative defense to eviction. Eviction is retaliatory. This property was subject to the ordinance. Section 150 defines a retaliatory eviction. The judge should have dismissed the case and given the tenant damages. 2 months damages are the partial penalty there. But what did the judge do? Then turn to the landlord. Looked at the landlord, rocked in his chair, turned to the tenant, and said, "Ma'am, in view of this," and I'm sitting there ready to go out and call Kathy Clark, the executive director of the Lawyers Committee for Better Housing, because I want to report to her the first recorded case in history, according to their own surveys, where a tenant actually prevailed as a pro se tenant. And the judge looked at the tenant and said, "In view of this, ma'am, I'm going to give you 2 extra weeks to move out." 2 extra weeks to move out. The PowerPoint presentation that you're seeing very little of, because we kind of did it as for a variety of reasons, but we weren't certain how to present this all today. The PowerPoint presentation will be available on the internet. In creating the PowerPoint presentation, we tried to cover everybody's presentation, and there's lots of notes, author's notes that are available with it. I would urge you all to, when we tell you about how to get it, to download the PowerPoint presentation and read it and read the notes as well. We're only going to cover a part of it today because there's just too much to cover. Okay, so why are you here? We're going to try to tell you a little bit about what the ordinance does. And part of the underpinnings of the ordinance, there's no recorded legislative history, other than what Professor Rose and other people involved with it can tell you. It's not like Congress in Washington where they record everything, or even with the state legislature. There's no recorded history to know some of the background of the ordinance, but there is some legislative history of some of the law of Illinois that does help give us some guidance. Part of the purpose of the Chicago Residential Landlord Tenant Ordinance is to provide a vehicle for tenants to have rights. This is primarily an outgrowth of the civil rights movement in the 60s and the Vietnam War and the tremendous rush to recognize that the people need rights, not just rich people or landlords, but everybody needs rights. And it's also been referred to as evening the playing field between the rights of landlords and tenants. So how does it do it? And that's what we're here to talk about. First of all, pro bono is a good reason as any for lawyers to represent tenants. Now, there's a number of ways to represent tenants. David Morris is going to tell you how a tenant can be plaintiff under the Chicago Residential Landlord Ordinance, because there's lots and lots of provisions that protect tenants and give them rights. Modest example, not to take any of David's time, but a landlord, if the property is covered by the ordinance, must deal properly with security deposits. Now, it ain't rocket science. I hear landlords all the time complain, it's too complex, it's too hard. And I keep telling them back, do you have a 7th or 8th grader in your home, maybe a 6th grader? You know, do you have a grandchild that age? Do you use a computer? What's so hard about remembering to pay interest every 12 months? What's so hard about that? It's not very hard. If you got CDs, you go and renew them and get your interest then. It's not very hard. But nevertheless, you know, landlords are up in arms because of some of the provisions about security deposits. And in order to give landlords encouragement to take care of tenants properly, because security deposits are tenants' money, the penalties are admittedly severe, but intended. You know, so is the income tax. If you don't file your income tax return, you're going to have some severe penalties in addition to what you owe. So it's an inducement. The penalty is 2 times the deposit, even for non-payment of interest. The interest rates are very low. But the penalty is pay the interest, pay 2 times the deposit. And then my favorite section, and I think one of your favorite sections, will be Section 180 of the Chicago Residential Landlord Tenant Ordinance, which is part of your handouts, which provides that if tenants have to hire a lawyer and the tenant is the prevailing plaintiff, then, wonderful world that it is, the attorney's fees are shifted from tenants paying us to the landlord paying us. Wonderful. It's terrific. But the first reason to be involved and interested in this type of work is that pro bono is good. Now, let's look at a typical eviction. Typical eviction, the tenant doesn't pay their rent on the first day of the month. A very aggressive landlord got a lease, says you got to pay by the first, serves a 5-day notice. Lots of intricacies and interesting things that I've learned, because this is not as easy an area of law as I thought 20 years ago. But again, it's not the Internal Revenue Code and it's not rocket science. But let's assume the landlord waits the right number of days and files a lawsuit. The normal time for return of a summons, maybe 14 or 15 days. Assume the tenant has been properly served. The case comes up the first time, and tenants really don't know that this is going to be a trial. You know, it says it's for trial, but what does a pro se tenant know or understand? So they go to trial, and again, based on lawyers' committee and a lot of things that I've seen, although once in a while a tenant can win, tenant goes to trial, and based on the lawyers' committee report, they lose, and only 5% of them are represented by attorneys. Now, those represented by attorneys who know what they're doing are treated much differently. Example, and things that you can learn to do, is file an appearance in a jury demand. Now, a lot of judges are angry about that because it's a delay tactic, and I think their attitude generally, in my experience, is, you must be a no good person to a degree because this is only for delay. We're an eviction court and we're supposed to evict people really quick. Well, what happens, and I'd like to say that if George Bush and Blagojevich and Mayor Daley were all there beside the landlord and saying, Judge, I object because the tenant has filed a jury demand, well, the ordinance gives them the right to do that. They can file jury demands. What happens if they file a jury demand? Timely. Case continued automatically for a week. And again, that big three couldn't do a darn thing about it. That's just the way it works. Case is transferred from the room it's in, goes to 1404, which is now grossly overloaded with blokes like me and others, or tenants who have gone to the good facilities on the 6th floor of Kent Law School and learned a bit about some of the ropes that they can use to their advantage. First time up in 1404, assuming counsel appears, you have a right to discovery in eviction. It's not a small claim for purposes of forcible entry and detainer. You have a right to discovery, and generally the judge, unless he really or she doesn't like you, and I seldom see that, will give you 14 days to file discovery and to file responsive pleadings if you wish to. Takes time. There's some landlords who are very angry, even I think with their own lawyers, over why do I have to do this? I've been a landlord for 50 years. I've never had to respond to discovery. Why do I have to deal with all this? But they do. And sometimes landlords are not that quick to respond to discovery. But the present practice in 1404 is not to set a case for trial unless and until discovery is completed and all other motions are disposed of. Well, again, going back to what I said at the beginning, and depending on your point of view, if you think that affordable housing is a privilege, and if a fellow or a woman lost her job, and it had been a good job, of living check to check like a lot of people do, getting them out in 30 days, making the kids go to a different school, making them homeless for a period of time, so what? That's just the way it is. But I'd suggest that that's not the way it should be. So a good lawyer gets involved in this process, and the result is that the process is prolonged and delayed. Now, I talked about the case where the woman got evicted. A lawyer would know that Section 150 of the ordinance provides a defense if an eviction is retaliatory. And you'll hear from Larry Wood on this topic and many, many others. And again, I'm not trying to invade his province, but just so you get a flavor for how things can get balanced both with tenants as plaintiffs and tenants as defendants, if those facts exist, not necessarily that severe. Maybe it's no heat. Maybe it could be a lot of different things, electrical plugs that just never seem to work, or tenants taking advantage of some of the other provisions of the ordinance that give landlords motivation to do the repairs. A lot of landlords, not advised by competent counsel, may take a long-term tenant who finds out about the ordinance, for example, and has the audacity to demand, that this refrigerator that doesn't work, which is the landlord's, or the heat that never is up to par, or turned off in the night that isn't up to the requirements of the city of Chicago. And they start demanding these things. And you know what they're labeled? Troublemakers.